Welcome everybody to today's event, introducing EnfTech, a technological approach to consumer law enforcement, co-hosted today with UNCTAD with support from the UK Research and Innovation Fund at the University of Reading. So today we're going to explore how we can leverage the very best of technology to help enforce consumer protection at the speed and scale that consumers deserve in today's fast-moving digital markets. This event couldn't have happened without so many wonderful, knowledgeable speakers who are ready and willing to share their experiences and its applications of technology across borders with all of you here today. And that's something personally I've known for a long time in the world of consumer protection, and something also which UNCTAD excels at facilitating, a willingness and openness to collaborate and learn from each other, all with the shared goal of improving consumers' rights and access to justice. So we should have over 100, almost 200 attendees today, many from CPAs who will be at very different levels of ICT capacity and experience. So some of you will be here to hear about these ideas for the first time, others are here to share best practice, but we're all here to learn together. Can we have the next slide, please? Here's a quick overview of today. We're going to be starting with an introduction from Teresa Moreira from UNCTAD, followed by myself and Christine Riefer talking a bit about what we mean by EnfTech and why we think it's useful. Then we'll get straight down into hearing from the people who are actually delivering a range of enforcement technology applications in their authorities. We'll have a short break for coffee or to grab some food, depending on your time zone. And then Arno Isagari-Villa will lead a discussion with regional authorities from Eastern and Southern Africa, Latin America, and Southeast Asia, who will be looking at how EnfTech tools could help with international and regional cooperation on consumer protection. And we'll be aiming to finish in about 3 hours at 1500 CEST. So in the spirit of exploration and an openness, I'd encourage all of you to make good use of the Q&A, and you can use that both to ask questions and also to put your comments. So use the Q&A for both questions and comments. And please, if you could share any examples of how you're using technology with any of your consumer protection tasks, that would be fantastic as well. And you can also email any links to info@enftech.org. Very brief housekeeping, the meeting will be recorded, it will be available afterwards, and we'll let you know where you can find it. And we're hoping to share the PowerPoint presentations there too. Please enter your comments and questions in the Q&A. We may not get to all of them, but we'll do our very best. And finally, please enjoy the day. I'm now going to hand you over to Christine Riefer and Teresa Moreira. Thank you.
Thank you, Liz, and welcome everybody. It's a great honor to not only welcome you here, but also introduce Teresa Moreira, who has kindly agreed to open the event. Teresa is probably well known to many of you. She's the head of the Competition and Consumer Policies branch at UNCTAD, and she has many years of prior service in consumer and competition law enforcement agencies. So she completely understands what's going on the ground, as well as driving policy at an international level. We are very grateful to have her. And without further ado, I hand the floor to you, Teresa.
Thank you very much, Christine. Greetings from Geneva to all of the participants and the speakers that are with us today. Well, good afternoon, good morning, and good evening, according to your time zone. I would like to start, dear colleagues, to thank Professor Christine Riefer for agreeing to co-organize this first seminar on introducing EnfTech, a technological approach to consumer law enforcement. This is, of course, the result of Professor Riefer's long engagement with UNCTAD and concretely with UNCTAD's research partnership platform on competition and consumer protection, and really illustrates her leadership in this field. As most of you will know, UNCTAD is the focal point on consumer protection issues within the United Nations system and the custodian of the United Nations guidelines for consumer protection, which were lastly revised in 2015. In its resolution on consumer protection of 22 December 2015, the UN General Assembly recognized that despite the diversity of mechanisms and legal cultures that exist across member states, consensus is also established on the need for common principles that establish the main characteristics of effective consumer protection legislation, enforcement institutions, and redress systems. And this is an integral part of UNCTAD's work. Although UNCTAD, of course, does not have any enforcement powers, we build consensus on areas that are important for the full implementation of consumer policies, including enforcement, through the meetings that we hold annually of the Intergovernmental Group of Experts on Consumer Protection Law and Policy. We also contribute to the generation of research and analysis on consumer protection issues that frequently include enforcement. Finally, UNCTAD conducts technical assistance and capacity building for developing countries' government authorities, and the issues related to enforcement are common in those activities. In a nutshell, UNCTAD does not enforce consumer protection law, but addresses enforcement issues as an integral part of its work. So I'm going to talk a little bit about, of course, the challenges in enforcing consumer protection in cross-border digital consumer markets, particularly for authorities in developing and emerging economies. And I will take this in parts. I will start a little bit about digital economy, then on enforcement in digital economy, and finally on cross-border enforcement in the digital economy. So starting with consumer protection in digital markets. In 2022, the number of internet users reached 5.4 billion, accounting for 66% of the global population, compared to 54% in 2019. The growth of the digital economy depends on the trust that consumers place in it. Indeed, according to an UNCTAD joint report with CIGI Ipsos, on the state of the global digital economy, consumers refrain from purchasing goods or services online, mainly due to a lack of trust. Another such report concluded that as distrust of the internet prevails, global citizens are taking precautions, one of which is making fewer online purchases. The UN guidelines for consumer protection contain a specific section on e-commerce since 2015, and recommend that member states should work towards enhancing consumer confidence in e-commerce by the continued development of transparent and effective consumer protection policies, ensuring a level of protection that is not less than that afforded to other forms of commerce. Despite this fragile consumer trust, UNCTAD estimates show a significant growth in e-commerce during the COVID-19 pandemic, especially in online retail sales. The share of ICT goods in merchandise imports surged from around 13% in 2019 to nearly 16% in 2020, the largest annual increase since UNCTAD records began in 2000. In 2019, 53% of internet users shopped online, and this proportion increased to 60% following the start of the pandemic, according to statistics across 66 countries. That year's UNCTAD's Digital Economy Report already highlighted the two main drivers of value creation in the digital era: digital data and platformization. In the context of the digital economy, consumer protection focuses on issues of access, the right of information, of information, education, and redress, objective online advertising, product safety, online payments, and data protection. The obligations of online businesses, particularly in platform markets, are also a major area of work. I will not delve into each of these to stay within my allocated time. So let me now turn to the enforcement of consumer law in digital markets. As business to consumer e-commerce grows, ensuring the observance of consumer protection laws in the digital economy becomes even more necessary. Consumer protection enforcement powers may either be attributed to a single government agency or shared among several relevant government institutions, such as the Consumer Protection Agency, the Financial Services Authority, the Data Protection, and the Telecommunication Regulators, just as examples. In 2018, 87% of respondents to a survey by the Organization of Economic Cooperation and Development, the OECD, had arrangements in place for cooperation at national level and were making significant efforts to increase and widen cooperation with other public bodies working on consumer policy. Therefore, considerable efforts are made to adapt enforcement to the digital economy context, such as online sweeps, investigations and sanctions, and there is a growing trend to set up specialized units for e-commerce within consumer protection enforcement agencies. These units may also be dealing specifically with data analysis, as we know, and gathering intelligence, of course. Online sweeps are a set of checks simultaneously carried out on websites to identify breaches of consumer law in a particular or several sectors. They usually involve a two-step process whereby enforcers screen websites to find breaches and use this information to carry out enforcement actions or to request traders to take corrective measures. This tool is particularly effective when used in a coordinated manner by various consumer protection agencies worldwide or at regional level. The European Commission and the International Consumer Protection and Enforcement Network, ISPAN, regularly organize international internet sweep days to build consumer confidence in e-commerce by dedicating a day to these intensive searches of suspicious websites, which might lead to enforcement actions targeting fraudulent and deceptive conduct emerging on the internet and other forms of electronic communications. According to ISPAN, sweeps are effective in the following: improving market conduct by demonstrating an enforcement present online, raising the profile of each participating agency by promoting their involvement in a significant event with agencies from over 30 economies, facilitating further action by each agency from education, enforcement, and international referrals in light of information revealed from a sweep, and broadening internet users' awareness by releasing information through the media. In 2020, UNCTAD proposed policy recommendations for effective consumer protection online, which included that consumer protection laws and policy are technology neutral to allow for future technological development, to harness new technologies to maximize the impact of product recalls and deal with the distribution of hazardous and unsafe products, in particular if they have been recalled in other jurisdictions, to entrust consumer protection agencies with enforcement powers to conduct online investigations, impose sanctions, and engage in cooperation in cross-border investigations, and to ensure that the necessary resources are devoted to addressing cross-border challenges of consumer protection in the digital economy. And this leads me to my last point, which is cross-border enforcement in the digital economy. Since 2015, the revised UN guidelines for consumer protection contain a very detailed chapter on international cooperation, which also covers specifically cross-border cooperation. The UNCTAD World Consumer Protection Map offers a very good source of data to analyze the current state of cross-border interagency cooperation. The map presents the legal and institutional framework on consumer protection in UNCTAD member states, which you will know are 195, and provides an updated and comprehensive review of consumer protection worldwide. So our research paper on international cooperation in consumer protection of December 2020 presents the work of existing regional and international organizations and networks and reviewed cross-border cooperation in consumer protection, also in enforcement. It found that consumer protection agencies rarely engage in cross-border enforcement cooperation, and when they do it, it's mainly among developed countries' authorities. So 60% of respondents reported no experience in cross-border cooperation. Even though this is almost 2.5 years ago, I think there's quite a lot of room for improvement. So also, as recently signaled by the OECD and by the UN General Assembly resolution on consumer protection, applicable law and jurisdiction is an obstacle which needs to be addressed in a more effective way to enable enforcement through international cooperation and consultations. This issue is larger than the traditional remit of consumer protection agencies and will necessarily involve cooperation among ministries of justice and foreign affairs. However, in an increasingly interdependent global economy where international trade is significant and with growing online cross-border business to consumer transactions, especially since the outbreak of the COVID-19 pandemic, It is in the interest of states to address the issue of applicable law and jurisdiction, specifically for consumer law purposes. The related legislative and institutional challenges include the lack of legal powers to address cross-border unfair commercial practices and to engage in cross-border cooperation, handling sensitive information confidentially, and language barriers. Currently, there are few regional frameworks in place that specifically address cross-border cooperation, especially for developing countries. Finally, and perhaps more importantly, international cooperation in consumer protection is only feasible when effective national laws, policies, and institutions are in place. Although most of the developing countries and least developed countries participating in UNCTAD's World Consumer Protection Map reported having enacted consumer protection laws, the majority still need support in reviewing them to keep up with recent developments or developing secondary and implementing legislation. They also need to build capacities of institutions to effectively fulfill policymaking and enforcement roles for consumer protection. And there are added challenges, as we know, in what regards digital marketplaces. I believe here is where EnfTech can really play its transformative role, whether using artificial intelligence to improve triage of claims, deploying bots to conduct sweeps, or harnessing smart contracts to avoid abusive clauses. The use of technology for enforcement purposes can only bring benefits, especially to developing countries that are less resourced. So I look forward to our discussion today to define the concept of EnfTech, to assess the applications of EnfTech, and to discuss and learn about its implications for international cooperation. Thank you very much.
Thank you so much, Teresa, and for also putting this landscape and the reasons how we get to EnfTech and why it might be so important, and give us the opportunity to indeed pursue this work. So without further ado, we're going to move straight on to defining what EnfTech is. And for that, Liz is going to join me. And perhaps we can have the slides that we have prepared to come up at the same time. The idea for our participant is for us to just explain a little bit where this concept comes from and where we are hoping to go with it. So if we go straight to the next slide, perhaps where it comes from, very briefly, as has been mentioned very kindly by Teresa, we started the work really last year with some work on a project on cross-border enforcement of consumer law. And one of the key recommendations that we made was to explore a technological approach to consumer law enforcement as a way to find solutions. And I was very fortunate to be a keynote speaker at the IGE last year, where we floated this idea. So to explain to you the work that we have done, next slide. We worked with Liz last year with a cross-border mindset. And we identified that technology could really solve a lot of problems. And we found technology in different places and under different guises and different names as well. So we came across an awful lot of literature on legal tech, which is effectively the pool of technologies that are being used by lawyers and law firms to enhance their analysis and their application of the law. We also came across reg tech, regulatory tech, which is effectively the technological solutions that are being developed and applied by companies, businesses out there who want to be compliant with their legal obligations. And we also came across perhaps what is the most advanced field at the moment in something resembling enforcement is supervisory tech, SupTech for short, where supervisory authorities have deployed quite a number of sophisticated and less sophisticated tools that use technology to really help them in their enforcement efforts, as well as their other tasks. Having looked at there, we didn't feel that we could use RegTech or SupTech to really encompass and translate what enforcement authorities would need in a consumer law context. So Liz had the brainwave of coming up with the idea of carving out a field of the literature and talking about enforcement technology, and to start thinking of this entire field as classifying the technologies by reference to the user of the technology, since that was clearly the way the literature had already gone with RegTech, legal tech and SupTech. So when we are talking of enforcement technology, what we're really talking about is what are enforcement agencies doing, what functions they can fulfill with the technology. Next slide. But EnfTech is a broad term. We have left it to be quite broad, but we think it can be a term that will evolve in its meaning. At the moment, it pretty much means what enforcement authorities do, can do, or need to do. But we're really hoping that as the technology evolves, we will be able to see EnfTech move from that place to a place where EnfTech is used to self-execute sanctions. In other words, what we are hoping the technology can do is to move consumer law enforcement from largely an ex post function to an ex ante function to improve outcomes for consumers. But this very much depends on the state of the technology, and that's where I hand over to Liz. And we can have our next slide as well, please.
Thanks, Christine. So the next major thing that we did was to look at how we might understand the types of EnfTech that we found to be in use, and using a typology from originally developed by De Castri, who talks about generations of technology. And these are continuous, so they're not separate, they build on each other. And we found that many applications could be thought of as being part of one of these 4 generations, obviously with some overlap between, because real life is never as neat as a table in a slide. But broadly and simply, the generations talk about the type of analysis and insight that can be delivered at different levels of technological maturity. And it takes as its starting point the way in which the data is made available. And when we go to the next panel, we'll be looking at live applications of live examples of applications. So you might want to think about where they fit within this generation scale, or think about what you're doing in your work and where that might sit. So very briefly, generation 1 is about descriptive technologies at quite a foundational level, where you might be putting paper records into a database with a very basic infrastructure. And really that gives you the ability to describe, to look at what patterns and problems are occurring. When we get to the diagnostic stage, this has a bit more automation of data coming through into agencies, so perhaps by a web portal. And this lends itself to a much richer analysis of the kinds of information you're seeing. So diagnostic is really not just what's happening, but why it might be happening. What patterns are there? Could we hypothesize as to what might be causing problems? Somewhere between 2 and 3, there's an increase, an uptick in the use of more automated tools to analyze much bigger data sets. We have big data, which gives more frequent, more diverse information, and we can also use technology to analyze and model in a more sophisticated way. So let's think about the predictive stage as what's happening, why it's happening, and also what could happen next. So here we find the capacity to deliver something a lot more sophisticated, perhaps detecting issues at a higher volume, unfair clauses in contracts by getting a machine to read the contract terms, a more detailed level of why problems occur, perhaps identifying profiles of consumers or particular times that things happen, or particular sectors or practices. The ability to predict problems is moving into the sense of having a more anticipatory idea of what's going on. And as Christina mentioned, this could be quite significant in terms of moving to a more ex ante approach. So Generation 4, described as prescriptive, again, another level of detail. What, why, what next comes in a lot more detail, plus perhaps the opportunity to propose an anticipatory action. And what we're very interested in terms of EnfTech is where it can become something which in the future could actually execute an action on behalf of a consumer, whether that's a remedy, a sanction, a correction or preventative measure. Now, we've seen this type of automatically executed remedy already in areas like copyright infringement on content platforms, or in use by marketplaces who are detecting counterfeit goods on sale. So we've seen it's out there. Our question is, what's its capacity to be used for consumer protection? And again, what's its capacity to perhaps be used to anticipate where bad practice might happen and warn of that before it occurs, which is something that could help prevent problems reach the market, and which seems to us to be very important in this fast moving digital consumer markets that we're all part of. Can I have the next slide, please? So this event's going to be an opportunity to learn about the development of EnfTech and how it might be impacting consumer protection agencies across the world. It's the start of a lot more work in this field, and we're really interested for you all to share ideas, to see some case studies, and to learn a bit more about it. The other thing which we think is critical in relation to Teresa's comments as well is to utilize the technology to be able to solve some of the cross-border enforcement issues, if that's possible. So baking in cross-border design and thinking into EnfTech at the outset is going to be really, really helpful. Okay, so now it's my great pleasure to hand over to Professor Martin Ebers, who's an expert in, well, all sorts of things, it seems, law, AI, robotics, and he's going to be hosting a panel with a fantastic lineup of speakers from all across the world who are going to be sharing their practice. Thank you, Martin.
Yeah, thank you so much for this warm welcome. And first of all, thank you to Christina Riefer and also to Teresa Mora for this wonderful event. In this session, we will talk about applications of enforcement technologies. We will learn what applications exist, how do they work in practice, and what can we learn from them. And to this end, the session 1 will be divided in 2 parts. In the first part, we will have a talk by Margarita Tu from the European Commission. We will talk about the EU e-lab at the European Commission. Then Luisa Crisgiovanni from the Italian Euro Consumers Alter Consumers will shed some light on the Cycle project, which is about consumer complaints handling. And thereafter, Ruth Castello, the Undersecretary for Consumer Affairs in the Fair Trade Enforcement Bureau in the Philippines, will talk about ODR tools. Then we will have a very short discussion. And then in the second part, we will have 3 more talks. One by Dries Kuipers from the Dutch Authority for Consumers and Markets, who will talk about AI tools being used to detect fake pricing and dark patterns. Then Piotr Adamczewski and Jacek Maciek from the Polish Office of Competition and Consumer Protection, who will talk about another AI tool for scanning contracts for unfair clauses. And last but not least, Stacy Proctor from the US Federal Trade Commission, who will talk about the Consumer Sentinel database and much more. So without further ado, I would like now to introduce our first speaker, who is from the European Commission, Margarita Tu. She is a legal and policy officer. She works at the EU e-lab, which was set up to conduct online investigations for national consumer authorities addressing or preventing mass-scale breaches to consumer law by traders marketing and selling on the internet, as well as safety concerns of the products using advanced or emerging technologies. And she will talk and introduce us to the EU e-lab. Thank you, Margarita. The floor is yours.
Good morning, good afternoon, good evening, depending on where you are. Thank you very much, Martin, for introducing me. So first of all, I would like to start it by showing my appreciation to the team for creating this event. So thank you very much, UNCTAD, University of Reading. The time to talk about enforcement technology is now, and I'm delighted that you accepted having us and to that we have an opportunity to share what we are doing with the broader audience. So I would like to start with the first slide, and this is a good next slide, please. And that's a good opportunity to circle back to what we discussed before. So what is happening? Why now? Why do we need specifically the enforcement technology? So my name is Margarita Tuch. I work in the Consumer Law Enforcement and Consumer Redress Unit of the European Commission. And our role as the European Commission is to look at the digital single market. So which is composed of the EU member states plus the members of the European Economic Area. So we are looking at actually 30 different countries at the markets of 30 different countries that have the right to trade cross-border. So especially in the digital sector, but not only there, the boundaries are blurred. Boundaries are blurred in terms of consumer behavior, but also in terms of how easy it is for the companies to relocate. And also how the companies can learn from each other. So what we see is that the proliferation of bad practices is very, very rapid. So you have one company that engages in questionable marketing practices or questionable selling practices, what we call the unfair commercial practices in terms of the European law. And the others see that it is working, that it allows to raise the profit margin and follow the suit. So then again, what we saw in during the pandemic, that the influence of digitalization is not limited to e-commerce at all. So businesses offline, online, make use of digital advertising, search engines, social media marketing like influencers, dark patterns are everywhere. So we are actually looking not only at e-commerce, but what is happening, how the consumers are targeted in principle globally. On the other hand, as the colleague said before, not all the authorities have the same capacities, not all of them have the same budget, the same team, and how it influences the European digital single market. As I said, it's very easy for the companies to relocate. So on the European level, we simply cannot afford the enforcement gaps. So while understanding that the authorities might be in a different stage of readiness to perform digital investigations, we need to help all of them. Plus, the way that digital markets work, and again, not just e-commerce, but also digital advertising and so on, then the issues that we face, they cannot be overcome just by individuals alone. So this is just too massive. It proliferates too quickly. The harm is done before it can be contained. So we need to look past the methodologies of traditional enforcement. Now, how can we do that? And for that, I would like to see the next slide, please. So how we work in our context. We have the Consumer Protection Cooperation Network, which is composed, we have a legislation applying to all EU member states plus Norway and Iceland. Then it is the national authorities, the national enforcement consumer protection authorities are working as one network specifically when it comes to widespread infringements that affect more than one country, and especially the infringements with the union dimension. So again, all the countries are organized differently. Overall, we have around 400 national authorities nominated as responsible for certain types of consumer legislation. Then on the other hand, us as a European Commission, at the moment, we have no investigative or enforcement powers of their own. We have a stake in functioning of the European market, but we cannot investigate, we cannot impose fines. So with that, with the groundwork, we actually rely on the network. How it's done is done by sweeps, which are coordinated screening on the websites. It's done by coordinated actions by the national authorities. So then some authorities would take the lead, and the issue with the trader will be approached not just by different authorities in the different member states individually, but in a coherent manner. So then again, since you see our 400 authorities, that's actually quite a lot. So we already used collaborative tools for years. It became much more accelerated during, much more prevalent during COVID, where we even were not able to have meetings. So we use collaborative tools such as wiki platforms to agree on approaches, to share information. But the next step of that was if we could collaborate, if we could use tools to investigate, to detect, investigate, and to prevent infringements. Which means that again, during the time of COVID, the CPC authorities in the Commission thought that the time was ripe to introduce not just the collaborative tools to agree and share information, but collaborative platform to perform investigations in the joint coordinated manner, and also to put together resources to be able to afford enforcement tools. Next slide, please. So the eLab, the European eLab, it's been live since last August, but the idea is not new. So what it consists of? It consists of three things. So the first one is the remote environment, which is also the mystery shopping environment. We provide the authorities the virtual machines, which looks like a normal Windows computer, where they could hide. They are not detected as the enforcement authorities by the traders that could block them or could personalize the offers that you don't see the infringement. Then it is separated from the government network. We use the VPN software, so you could choose which countries you appear. Basically, you replicate the journey of the average consumer with all the dark patterns that the consumer sees, but you can collect evidence by using a screen recording tool. Then you can also collect the evidence, you can transfer it, it's completely secure and isolated. You can use the evidence in court. That's the first part of the eLab. Then again, just the mystery shopping might not be enough. So sometimes we know that the shop has a problem, but we don't know who's behind it. Next slide, please. That's why we are also offering our friends investigative software. These are examples that we are offering now. Again, methodologically, what we did, we actually took the steer from the CPC network. We talked with the investigators, we talked with the national authorities. What are your use cases? So what do you want? What do you want to catch? Then, like you see that we have domain tools and Maltego, and then our investigators remain in full control of the data. And then, of course, it is quite different on how you what happens with the data. So for you, it might depend. So some of you might be able to use what you get from this investigative software as evidence, but for some of you, it will be a hunch. a clue, and then you would have to verify it, but in a way, it's an excellent start. And of course, we also invest in training and support. Next slide, please. So on top of that, we hear from the authorities that actually the general investigative software is a really, really useful start. So sometimes the cases could not be investigated without the software. But what is happening? What is actually the biggest appetite is the network. And then we go to EnfTech. Are the tools which are specifically targeted for the consumer protection use cases. So like here, we do not talk about the broader artificial intelligence like ChatGPT. Also here we talk about really, really narrow applications, artificial intelligence that, like maybe does one thing, but does it well. So our first project that was actually already tested by the authorities is we had a price reduction sweep last year to that it basically was a web scraper that analyzed if the shops that put products on sale, if they used artificial discounts, if they inflated the prices artificially. So then they could tell the consumer that like 30% off. That's why buy now, but in fact there is no discount. And since there is a European legislation on this, it was actually not that hard to make the tool because we knew exactly what needs to be verified. So then again, what we are also the other example that we have is that we start looking at the fake reviews. Again, it's a very, very new project. Then, as you know, our consumers rely more and more on reviews instead of relying on just, like logic or analyzing specifications. So the research shows that 20–30% of the online reviews are fake. And what we do, we try to use artificial intelligence to predict which reviews are fake and which are not. So I would like to very quickly show you the examples of the tools we have. So if we could do the next slide. So this is how, for example, the price reduction tool would look like. So actually, now I'm thinking that we might, like edit it a little bit because for the public recording, because here we have how do you call it, the actual website. So we are like, again, this is only a prediction. It is not an automated infringement. The inspector actually will have to verify it. But the tool itself is very good because it allows to catch something that individual inspectors cannot catch. So basically what you do, you deploy it and you look en masse, and you only have to investigate the cases where the AI already found a suspicion. So you don't lose your time on looking at all different websites. You really do it in a very, very targeted manner, where you already have a reasonable suspicion that there is an infringement. So the next slide, again, I will very quickly show how the fake review detector could work. So again, the purpose is not to find every fake review, but the purpose would be to assess if the website would have a high proportion of fake reviews. And the technology behind it is the natural language processing. Basically, we try to predict if the interview was computer generated or the interview was written as a human. And if it was written as a human, if it is a human who actually has experience in the product. If it is not the case, then the review is presumed fake, and the website that has a high proportion of suspicious reviews will be flagged for investigation. So finally, I would like to show you the last slide is where like if this presentation is interesting for you, and you would like to do something like this. So we have a privilege of the European Commission that we can afford this package. but if you're individual authority, so you want to do something similar, where to start? So I would first encourage you to use the tools that are already available for you. So just in the developer tools in your browser, you can already see, visualize the what is possible, what we visualize on the mobile sites. You can visualize the website code. So this is, you don't have to pay for it, you don't have to install it, this is already available. Then I would also encourage you to work with open source intelligence and open source tools, like for example, ShareX that we currently use. This is a free tool. You can actually, it does require installation, but then you would be able to to do the basically record all the consumer journey, and it even has the text recognition functionality, so it would be actually very easy for you to extract the information on the website. And then it would, also give you a timestamp, so you could use it as evidence. Again, it is completely for free. Then NIME Analytics, there is, a way to build your own scrapers. What is good about open source, that you would have a community support. So if, for example, your data scientists are the ones that are only starting, or there is no possibility to have a data science department, with the use of the open source tool, it is possible to get support from the other users. So then with a little bit of budget, what you can also do, it is possible to use the virtual private network. Then again, I hope that the web shops will not catch on it too quickly. Then with the virtual private network, basically what is happening is that you can check, visualize the offers in different countries, see that, for example, if your country is discriminated, and for that you would really need to have a budget. So then again, I probably went over time, so we got a little bit of a reminder here. So again, apologies for this. Now it's a good moment to give the floor back to Martin, and I'm looking forward with you to hear what the others bring.
Yeah, thank you so much, Margarita, for this very precise and interesting overview of the different things you are developing in the E-Lab. We will have the possibility to discuss this later, but first, it is my pleasure to introduce you to our next speaker, Luisa Crisi Giovanni. She has worked in consumer law for more than 25 years. After a degree in political sciences in 1992 at Milan University, she specialized in communication and EU fundraising at Bocconi. Later, she worked as a fundraising and project manager for a range of innovative projects at Euroconsumers. And since March 2021, she's also a member of the Consumers Policy Advisory Group of the European Commission. She also represents the Italian consumer organization Altro Consumo at BOIC as an executive board member. And today she will introduce us to the Cycle project, which is, if I have understood correctly, about collecting and analyzing consumer complaints. Luisa, please go ahead.
Thank you very much, Ibers, and thank you to the Reading University for hosting me, EnfTech as well, and UNCTAD. I think this is really a pleasure to guide you through this experience that we manage thanks to the EU grant acknowledged us by the consumer program, actually, because we thought it was very important to put consumers at the center of and to really find an answer to the scarcity of the enforcement capacity, which was described before, both by Teresa Moreira and also mentioned by Margarita Tuch. The question we tried to answer was how we could really better feed and collaborate with the enforcement authority to feed this gap of, let's say, lack of enforcement in front of several legislation and coding of consumer rights. We wanted to contribute more, but starting from a consumer perspective. If you go to the next slide, please. So we were convinced, this was in a nutshell the concept of this 2 years project that was just over last February, and we actually is now starting again with a new grant with a larger scope, but we were convinced that complaints coming from consumers themselves could be kind of source for speeding this journey related to enforcement, private enforcement and public enforcement, and actually try to tackling this issue of kind of delay or difficulty in tackling the let's say, misbehavior or unfair commercial practice or let's say, isolating the cases that could really damage the trust of consumer, especially online, but not only online. Therefore, also thinking ahead and imagine that the future would be not only to answer on the phone to consumer complaints or managing it directly face-to-face, we thought we should develop a framework and improve our already existing web complaints platform. So we upgraded it with introducing the Salesforce technology in order this data exploitation to become really the engine of public and private enforcement actions. Next slide, please. This is the overview of this project, including 2 partners, because we were kind of pilots, Spain and Italy. So actually we work together with our partner OCU in Spain. We upgraded the existing web complaints platform, which was a section of the main site of both organizations in Spain and in Italy, with this improvement of the interface, but mainly of the back end of the platform to really manage in a better way the categories of complaints, improving in this way the enforcement tools that we had, and also stimulating, if I may say so, the mindset of colleagues managing the data. So breaking silos also inside the organization themselves to in order to make the team managing the complaints collaborate more in a constant manner with the team who had the objectives of advocate and report to the authorities. So this also helped this implementation of the technology to have a mindset stimulated by the tool, but actually oblige us to look at the data together. And then, of course, in this way, we hope to have supported and hopefully continually do support the enforcement power of the authorities. And when is the case, develop coordinated actions when the infringement is, of course, multi-countries and widespread. And in the end, sharing the best practices that we noticed. Going ahead, please. I will now focus on the main and major task of the work package 2, which was about this upgraded of our existing platform. We actually complement this sending the complaint directly via our platform to the third party with the support, let's say, of the consumer association, meaning that we shape the template accordingly to the kind of topic that and issue that consumer raised, but let's say as much as possible with the consumer centric perspective. So not starting from the category of the CPC regulation, but establishing this template starting from the word that the consumer was searching maybe to complain and related to the complaint he was having. Then, of course, we provided also kind of redirection to the ADR and ODR points of contact with a kind of online finder of these places, because we discover also, according to the latest Eurobarometer data, that people, despite all the efforts of European Commission or consumer organizations, were not at all aware of the possibility not only to solve maybe or be in contact with the company, with the consumer organization, but also to go to the right EDR point to solve the dispute in a different way. So we wanted to provide again this kind of easier possibility to find straight away another solution also outside our platform. And we of course monitor the complaint activity and went, let's say, also and create this discussion starting from the moderation. Go ahead, please. And what was the result? You can see here. This is actually a kind of reproduction of the advice and templates available on the web platform that I described before, with the icons depending on the problems in the EDR finder. You can go ahead. These are the examples, but the most interesting thing, these are the categories that we created thanks to the technology where we gather the cases. The cases structured in these 9 categories with an eye to the categories created in the regulation to have a kind of common background to be activated later on: transportation service, communication, health, education, water, energy, consumer goods. And then of course there are in details many other subcategories, and thanks to the technology implemented, we can go with granularity till what was really the case of the single consumer who actually used the platform was about. If you go ahead, please. So the methodology was also to create a dashboard in the end to be able to report with the top 20 companies with most complaints, the top 20 companies with the highest number of unanswered complaints, also to stimulate also sometimes the companies. That was our role as well, to be the enabler of the market. So to put the consumer in touch with the counterpart trying to solve the issue. And of course, to identify, as said, the nature of problems. Of course, this was related, it covered as a scope, the companies who, in a collaborative spirit, participate to the platform. It's not exhaustive of the complaints that we receive on a daily basis, because we still receive by phone, but as the market is going online and the web more and more, we try to anticipate the flow. If you go ahead, please. Then these are the data that we aggregated in the first, let's say from May to January observation. And actually we could see trends in different sectors: consumer goods, postal services, water, energy. So you see a glance which were the issues, the variation, the issue. And if you took, for example, transportation services, whether it was more about in Italy and Spain about flight cancellation, or what are the issues in particular, in order to really then alert in a proper way, gathering this evidence and bring this evidence to the competent authorities. But if you go ahead, please. I will rush. This is again the example. You can go ahead to the next slide. Let's say that all these user content generated, if I make also data, we help us to not only classify complaints, at the same time answer to the people and provide a solution to the people question. We actually provided the enforcement authority via also the internal market system the alert when was the case, because thanks to the system, if you go ahead, please, we detected some infringement. One case was the Samsung case that we, for time constraint, cannot go through, but I just want to mention, but there is an alert that we raise via the system to the CPC network, as well as in particular, the competition authority in Italy already opened the case, which is pending for aggressive and unfair commercial market practices. But there is another one, which is the Citroen case. If you go ahead, please, that we detected, you can see later, next slide, please, through the platform. you can see that thanks to the technology implemented, we could monitor the appearance among the top 20 companies with most complained of sea trend in the month of August, with the variation with respect and compare to the previous month, because we do look at the dashboard monthly. They change a lot and increase from 20 complaints to 63 complaints, and it's still growing with variation of more than 133%, which generated the alerts and actually encourage us to go deeper and discover in detail what was wrong with it. And if you go to the next slide, we then add, of course, not just the artificial intelligence system and implementation, our legal analysis, and discover that was this issue of malfunction is caused by probably a design or manufacturing defect of the tank of this AdBlue additive for let's say, I'm coming to an end in just a couple of minutes. And of course, this is generating a request to consumer from 800 to 1,200 euros. And we receive already something like 300 complaints from consumer, which actually, if you go ahead, push us to raise the alert via the CPC network. I mean, the network of all the competition authority responsible for of course, implementing consumer law in Europe. And we raise both from Altro Consumer, and also we share with BEOC the cases to really raise awareness and actually try to stimulate this coordinated action and gain time and provide legal analysis. Of course, this is a case still pending, but let's say that we use the existing network, but try to, thanks to the implementation of the technology, also gather cases and feed the system. I think it's all. Next slide, please. I guess is the last one. Yes, and of course, thanks to this, the Italian Competition Authority opened investigation, which is still pending, and we are still collecting complaints. I hope supporting the network. If you go to the last slide and really finish, the main learnings of this experience were actually, again, the proof that thanks to this technology or way of working, consumer complaints data can really speed, in our opinion, the journey and actually structure the enforcement action or the reivindication that we could submit to the competent authorities. And of course, I cannot deny that we faced a lot of technological challenges also integrating into our existing database, or if you want, migrating this database into the new system, because you need to adapt. And so do not underestimate the integration when we are talking of a lot of data. But let's say that what stimulates us is to really have this consumer justice, data-driven future that we hope to have contributed to thanks to the cycle project outcome, because this is the proof that even consumer organization can really, provide a kind of piece of evidence to speed up the process, implementing new technology and starting from consumer complaints themselves. So this is the, let's say, a really interesting part of the story, that is the evidence that we bring in is kind of exploitation of the consumer complaints themselves. And hopefully, I hope you like it, but it's just the start of a journey, because the ambition is to, of course, share a lighter version of the tool with other organizations. So really help them to also from their side exploit the data of the complaints they receive and contribute to the work of the authorities to improve the enforcement of consumer law. Thanks.
Yeah, thank you so much, Luisa. We will move on with our next speaker without further ado. It's my pleasure to introduce to you Ruth Castello, who's the Undersecretary for Consumer Affairs in the Fair Trade Enforcement Bureau in the Philippines. Ruth is a lawyer by profession, having been admitted to the Philippine bar in 1994. She served 8 years as the city attorney for Marikina City and as a private practitioner in her own law firm, handling various litigation cases, clients, and legal concerns. And today, she will talk about consumer protection measures using technology, and also about ODR tools, so online dispute resolution tools. Thank you, Ruth, for being here.
Of course. Thank you, Martin, for the kind introduction. Good morning, good evening, and good afternoon to everyone. In the Philippines, it's already 7:20 in the evening. So I know that it is still morning or afternoon in other countries. So let me introduce to you some of the technological approaches that we have done so far in protecting consumers in the Philippines. You will see in the next slide. In the next slide, you will see some of the initiatives that we have undertaken in the last several years using technology. And I'm actually very glad to be here learning from other countries how you do enforcement using technology, and we would like to learn some more. So we have the iRegis. This is the Integrated Registration Information System. It is an online processing portal for sales promotion activities, business licensing for freight forwarders activities. We issue other permits and frontline services that are done by the Fair Trade Enforcement Bureau under the Consumer Protection Group. It is one whole function group under the Department of Trade and Industry. We are actually the biggest consumer protection arm among all agencies, government agencies in the Philippines, and we are actually pushing for becoming an independent consumer protection agency. With the iRegis system, the applicants or businesses will no longer have to go physically to the Fair Trade Enforcement Bureau office and submit manually the documents that they have for application. They can now easily apply at the comfort of their homes, wherever they are. And the service, which is a 24/7 accessible portal, can be, we can process the applications already, and consumers can also submit their complaints through the system. The second one, we have the DTI consumer complaints. We have the ePresyo application. This is a mobile application where we input all the prices of basic necessities and prime commodities that are given under the mandate of the Department of Trade and Industry. In the Philippines, we have around 20 basic necessities and prime commodities. These are the fastest moving products that are consumed by our consumers. As you know, we are a developing country, and we have a lot of citizens that have lower pay. They have smaller budget compared to the others. So we watch these basic necessities and prime commodities and make sure that there is sufficient supply and that prices are reasonable. We also issue suggested retail prices that are inputted into this ePresyo. Incidentally, let me say that presyo in the Philippines is price, which is derived from the Spanish term precio. So when you say ePresyo, it's the electronic price system that we have in the Philippines. Consumers can also access the system, and they can also even give us information on their experiences or their observations in the market. Like an example would be, they would go to a supermarket and the price of one particular product is higher than the published price that we have. So it has become easier for us to monitor retailers, supermarkets and grocery stores. We also have as another feature the location of these stores, so that consumers will not have a hard time looking for where they can find their basic necessities and prime commodities at the price that is published by the department. In the next slide, you will see the DTI Consumer Complaints Assistance and Resolution System, or we call this the DTI CARE. This is actually an offshoot of the Philippine Online Dispute Resolution System, which has been completed by the department through the Consumer Protection Group in 2020. Late 2021 to early 2022. We have launched this already, and this is actually an ASEAN commitment that the Philippines has made to the ASEAN's Committee on Consumer Protection. All ASEAN countries are asked to have this created, the online dispute resolution system. I remember hearing Teresa earlier about cross-border enforcement. This one is a complaint system that will have to cut across all the ASEAN countries. Ultimately, we will have, the ECCP will have the online dispute resolution system where all the countries, all the 10 ASEAN countries will go on board, and it's going to be very much easier for all these ASEAN countries to resolve complaints that are filed by one country against another. I mean, from one business establishment in one country to another. This is also, of course, this is handled by government, and the ASEAN governments, respective governments, will help each other and assist each other in resolving cross-border consumer complaints. Right now, the CARE system that we have is only used internally in the Philippines, and as soon as the ECCP is ready with their system, we can go on board. And then in the next slide, you will see the ICC, or the Import Commodity Clearance Verification mobile application. This is a system where the Bureau of Philippine Standards under the Consumer Protection Group issues import commodity clearance stickers with QR codes. So everyone in the Philippines may verify or make sure that the products that they are buying comply with Philippine national standards. All they have to do is download the system and then scan the QR code on the products that they buy. If the system says no record found, that means that the DTI, through the Bureau of Philippine Standards, has not processed or has not issued certification for the product, and so consumers will not proceed to buy it. In the next slide, you will see also we have the Philippine Privacy Trust Mark as well for the National Privacy Commission. So this is by another agency, but which we also implement in the DTI for consumer protection to make sure that Privacy Trust Mark will increase the confidence of the consumer that the data or the information that he has given to any business establishment or any retail or supermarket, that the information that he has given is protected following the Philippine Privacy Trust Mark. We also have other trust marks in the Philippines that we are yet to implement because we're still waiting for other systems and other implementing rules and regulations that will be prepared. So do we have another slide? Okay, so that is all, and we are most willing to learn from other countries on enforcement using technology, and we, of course, would most welcome any information that may be given to us. Thank you very much.
Yeah, many thanks for your talk and your overview. We will collect all your questions and then have a Q&A session when all the speakers have presented. So please feel free to type in and to ask your questions in the Q&A chat possibility that Zoom offers. So now we will have our next speaker, Dries Kuipers, who is a lawyer who currently leads the work on the digital economy at the Consumer Division of the Netherlands Authority for Consumers and Markets. He has 20 years of experience as an enforcement official in numerous economic sectors. He set up ACM's Behavioral Insights team and managed the team for the first years. In recent years, he has worked at the OECD on consumer policy. He is also an co-author of ACM's guidelines on the protection of the online consumer. And today he will talk about why ACM began to use tech for enforcement and give us some examples of AI tools to evidence fake pricing and dark patterns. Please, the floor is yours.
Yes, thank you very much, Martin, for this kind introduction, and also to the organizers for the very kind invitation to speak. I realized that by sharing my slides, which I'm going to try and do now, I will make myself invisible. So you will have to bear with me and look at the slides. Just to verify, Martin, can you see the slides all right?
Yes.
Thank you very much. So I want to use the next few minutes to talk you through a couple of things. I want to tell you why at the Authority of Consumers and Markets we have engaged in using technology in consumer enforcement, how we organize this internally. I want to provide you with the two examples that Martin already shared with you, tooling that we built in relation to price reduction and finding countdown timers. And I want to close off by sharing some of the lessons that we have learned from engaging into this expedition. So I'm not going to dwell too long on why we use technology, because I think the previous speakers have already shared quite a bit of their experiences and thoughts around this. I think I just want to say that I really feel that using technology is going to be essential already, but will become more essential in the near future to both make sure that we have sufficient oversight as consumer authorities, but also that we allow ourselves to gather evidence and analyze evidence in more effective ways. By the way, I don't think that we should use tech only in the digital domain. So I think tech has also a large field of application in, for example, the offline violations that we see in relation to consumer protection. I just want to highlight one here, is that we are currently looking into the use of AI to analyze the compliance of telemarketing chats that are being held with companies that engage in telemarketing. And as you can imagine, there is many thousands and sometimes tens of thousands of calls that normally we would either sample a few of and analyze, whereas we think now that tech would allow us the opportunity to look at those in a more holistic way and really go through them using an AI that can recognize certain words or phrases and then highlight for people to listen to. So yes, it is absolutely necessary in the digital economy. I think it will become more essential, as I said. Think, for example, about the developments in terms of a metaverse or gaming, which are very complex and large digital commercial spaces in which many consumers will find themselves today. And even getting access to these environments sometimes takes technology, let alone trying to identify what's happening in those spaces will definitely need more technology for that. So it is using tech to guarantee sufficient oversight, to gather and analyze evidence, but also to facilitate our internal processes. So I think a few of those were already mentioned by previous speakers, for example, analyzing consumer complaints or responding to them, but also processing large data sets. And I will come back to that. So moving on, first of all, I want to very briefly say how we work at the ACM. So the Authority for Consumers and Markets does more than only consumer protection. And we have set up a task force of data, which is called the Task Force for Data and Algorithm, which has about 10 to 12 people. And these people are all experts in the field of either data engineering, data scientists, or making, for example, the results of the use of tech visual. So the visualization experts. And we have people that think about the procedures that should involve data. So they think about data governance, about data ownership and data processes within the organization. Now, this team has, I think, existed for the last 5 or 6 years. And what they basically do is they build our tooling, the tooling that I'm going to speak about in a bit. And we really prefer using the in-house development of tooling versus the off-shelf tools that are also available. There's a couple of reasons. I won't go into all of them, but certainly one of them is the retention and safety of the data that we gather. So we absolutely are sure that that is in our house and is owned by us. They also, for example, of course, monitor and anticipate the developments in the market, so they know that which technology becomes available and what will be useful for us. They play an important advisory role in cases, also, again, to advise case teams on what tooling is available and could be used or actually could be produced by them. And I already mentioned the processing of large data sets. They've also written a set of guidelines internally that we use to that guides actually the process of web scraping and the decision making and tells us what we can and cannot or shouldn't do. Now, I think this is what you probably came for. These are the two examples of tech that we have used recently and are still using as two out of more examples. So one tool is a tool which was also mentioned by Margarita which is also available in the eLab, is a tool that can actually recognize countdowns or reference pricing. So the tool that we built predates the one that is available now in the eLab, and we're still using our own tool. And basically what it does, it's built on the European legislation that says that the price, the reference price, should be the lowest price handled by the trader in the last 30 days. I've given you an example. So it says a special offer from 177 euros now for 159.99, which means that in the last 30 days, the trader should not have had a lower price than the 177 euros. Now, what we've done, we've built a tool and ran it twice, which scans hundreds of products, or at least as many as we enter into the tool. And it facilitates a picture of the price multiple times a day on all the products. So it creates thousands of data points, and the parser, so a part of the tooling, is able to match all those on the product and tell us and be able to show us whether the actual price reduction was a real one or just a misleading one, as also mentioned by Margarita. So this allows us to scan massive amounts of websites and products on a reference pricing problem that we were never able before to do. That is the first tool I wanted to mention. And the second one taps into, I think, a wider problem, of course, of fair design, which we won't go into now. But of course, we know that there are many dark patterns out there. And one dark pattern, of course, is what we call misleading countdown timers. So these are countdown timers that give you the impression that something is scarce or time limited. But whenever the countdown timer is actually finished and the price doesn't go up again, or the timer repeats itself, we're actually creating some kind of scarcity towards consumers just to pressure them into a sale or into a purchase. So what we are doing is we also built a tool which has a bit of a smarter script and is actually able to recognize patterns in the website, finding countdown timers, and therefore again being able to scan many hundreds of websites at a single click and tell us where the countdown timer actually did start again or the price did not go up again. Of course, just one example in the middle, and only the Dutch readers will be able to read it, but I can tell you quickly, it is a matter of really fine-tuning and piloting these kinds of tools to make sure that they don't find the wrong things. For example, a recipe for a slow juice, which happened to have a similar pattern, but then not on hours, days, and seconds, but on lemons, tomatoes, and cucumbers. So moving on, we have been using tools for a couple of years now, building our own tools, and there's a couple of lessons that we have learned. And I just want to single out a few. There's a whole list here. But I think what is important to tell you is that developing tools takes time. It takes an investment, but it's absolutely worth it, I think. Yet again, tech is not the holy grail, so you will not be able to find all violations using tech as it stands. I mean, in the future, there may be more possibilities. And I think related to that is having the ability to use tech should not drive your prioritization. So the simple fact, the mere fact that you may have a tool that can find countdown timers doesn't mean that finding countdown timers is the most important problem out there. And I think the only two other ones that I really want to very quickly touch upon before time runs out is we have to make sure that we always include the human intervention. I mean, this is a requirement that we, I think, also put on markets in terms of using AI. And we also, I think, always want to make sure that we have a human checking whether a violation is really a violation and see the violation into the context. And I think the last one I want to close off with, and I think is a very important one, and I think it was referred to already somewhere in the beginning, is we know that by using technology, we can find much greater numbers of violations. And that also, again, raises new challenges in authorities on how to deal with those large numbers. Are we going to ignore them? Are we going to prioritize? Or in fact, are we also able to deploy technology at the back end of the process in terms of interventions? Now, I think that's a pretty hard one, maybe not so much in the technical sense, but certainly also in the legal sense, where I think legal process as it stands in many countries nowadays does not allow for such a thing or will make that extremely difficult. So I think I want to end with that challenge to all of us to also look at the legal processes so that they will match those capabilities in the near future. Thank you.
Yeah, thank you so much, Dries. We are still collecting your questions and will address them at the end of the two talks that are still now to come. Our next speakers will be Piotr Adamczewski and Jacek Marczak. Piotr is the director of the Polish office for competition and consumer protection, and he has considerable experience in the fields of cartel, abuse of dominant positions, and merger control. Jacek Marczak is the deputy director of the Polish office for competition and consumer protection and is responsible for nationwide cases concerning unfair trading practices in the food supply chain. And both will talk today about an AI tool for scanning contracts for unfair clauses. Please, Piotr, the floor is yours.
Thank you very much, Martin. Good afternoon to everyone. It's actually after 1 p.m. in Poland, so it's afternoon already. I just need to clarify that I will be presenting our project on my own because we thought that having the time constraint, it would be better and easier for the audience to go through what we actually achieved just with one person presenting. So it's actually a huge challenge for me because I can talk about this project for hours, but having in mind that I have just 10 minutes for presenting, I will focus on the main points which we learned from that. So on the next slide, I would like to show the main assumption which we had when we started the project in 2019. It was a 3 years project where we thought that we are at this stage of development of the agency with the using of digital solutions for communication, for case register, for case management as well, that we can also deploy artificial intelligence to better work with the cases, with our tasks on a daily basis. And we thought that a good solution for that will be using the matrix systems, engaging the people from different departments, from different branches, regarding the scope of their duties and their ability to actually work with the project. So it's a little bit different approach here in working. Not setting up the separate department, a separate unit, but working more or less as a task force for the special for achieving a special result. And of course, we wanted to enhance our capacity. We wanted to increase our efficiency, and for that, artificial intelligence actually is a perfect solution for the agencies which have the same responsibility as ours, like consumer protection. But for that reason, at the beginning of the project, we had to take 3 factors into consideration, which are included on the next slide. There were basically our need. So we had to consider what are the important tasks for us, and at the same time, which of them are most time consuming. Then we had to reconsider what kind of data set we actually have, what is already in our disposal. And finally, the last point, but also very important, what is the technology on the market? What was available at the time, which we could use? Next slide, please. And we thought that having in all that factors into consideration, that the best solution would be finding a possible artificial intelligence solution for detection of unfair clauses. And we didn't actually decide on what kind of technology we can use. We were really open for the market, having in mind that there's different solutions on NLP, on computer visions as well. But we decided to use this quite innovative way of public tendering, where we just presented our data set to the public, saying what is our budget, what are our needs, and let them to work with us on deciding what would be the best solution and the most effective technology which can be used for the task of agency. And actually, we organized this design contest where we compared different POCs, proof of concepts. And only on that basis, we decided on the vendor, which had the most efficient, the most accurate proof of concept. That one was actually granted with the contract. And finally, the technology which was used in this system was called transfer deep neural networks. And actually, it's pretty efficient and pretty accurate, as I can show you in later slides. So can I have the next one, please? So a few words about data set which we had. It was actually the most important input from our side. And we realized that we, in our disposal, we had like 10,000 entries of already decided unfair clauses. It was because we had this register of prohibited clauses already decided by the court. We had also our working decisions, but we had also plenty of soft letters, this kind of moral suasion letters to the companies, where we also decided on the fact whether the given provision is fair or is unfair. So on the next slide, I'm just showing an example how we structurized this data. So it was made in this way that it was easy later on for the machine learning to understand what it is abusive, what part of the clause is correct, and to have this fuel for the proper deciding on the provisions. Next slide, please. Here is also the additional information that we also included the justification why the clause is fair or unfair, just because enabling the machine to give us sound reasoning for why the machine actually is deciding, is flagging the provision as unfair. Next slide, please. Very quickly, to show how the tool is working. It has two ways of be fitted by the contract. So one is the user who can upload any document to the system by using scanning and OPR later on. And the second second way is the crawler, which can search for the standard contract terms on its own. And then the text is actually extracted, and it's possible for the people to monitor what is happening with the contract terms. And there is the flagging whether the machine is suggesting that's the fair or unfair clause. On the next slide, I have an example. How does it look like? So this is the interface of the Arbus. It's the name of the tool. And it's on the right side, you have the whole contract with indication in red, which provision is suspected to be unfair. And this is pretty easy to work on, because any employees who is actually dealing with that kind of cases has access to that through our desktops. And they can easily work with this interface. Next slide, please. To this final result that the tool can generate the outcome of our job. So, for example, I have here the situation where the tool actually flagged the provision as unfair, and it was confirmed by the employee. So there's the final decision is in the hands of the employer. And after just clicking generating a soft letter, all data actually is changed into the soft letter, which is actually ready to be printed and to be signed by our employees. So actually, this tool is helping us changing this time-consuming work of reading all that long standard contract terms into very fast process of just flagging and giving us the information that there is the suspicion of the violation, and the person, the human being, is actually approving it and immediately getting the final result of our job, which is a soft letter, or it could be also a statement of objections or final decision of the president of work. That's actually all within this time constraints. So I hope that I was able to present the tool to show how we work with it right now. Thank you very much.
Yeah, thank you very much, Piotr. Our last speaker of the first session is Stacy Proctor. She's an attorney with the US Federal Trade Commission's Office of International Affairs, where she focuses on the agency's consumer protection mission. Prior to joining, Stacy was a senior staff attorney in the FTC's Western Region, Los Angeles office, where she led and worked on many consumer protection investigations and litigations. Prior to joining the FTC, Stacy worked as a litigating attorney for other US government departments, including the US Department of Justice and the Antitrust Division. Today, she will talk about the Consumer Sentinel database, which is being used to identify and analyze complaint trends. And if I understood correctly, also about the BCP Tech Lab. Stacy, the floor is yours.
Thank you, Martin. And first, let me check. Can you hear me and can you see my screen?
We can hear you, and we can also see your screen.
Perfect. Thank you. Good morning to everybody. Thank you, Martin. Thank you to UNCTAD and the University of Reading. I appreciate you inviting me to talk about how the FTC uses technology. But before I start, please note that any remarks that I make are my own and do not necessarily reflect those of the Commission or of any commissioner. So some very brief background on the FTC. The FTC was established in 1914, and since 1938, the FTC has been charged with directly protecting consumers from unfair or deceptive acts or practices. So the FTC has been working to protect consumers for a long time. And throughout the FTC's history, technology has played an important role in helping us to monitor the market and ultimately enforce our consumer protection laws. So with that background, today I want to discuss 3 examples of how the FTC uses and interacts with technology. The first is our Consumer Sentinel Network, which the FTC uses to collect consumer complaints and monitor complaint trends. The second is our Tech Lab, and the third is our new Office of Technology. These examples are not exclusive, but they do show how the FTC has integrated technology in different ways and at different points to fulfill our mission of protecting consumers. So first, Consumer Sentinel. Consumer Sentinel is one of the most fundamental ways that the FTC uses technology. It is a powerful investigative tool and database that provides immediate and secure access to fraud and other consumer complaints to members of the law enforcement community. It includes consumer reports from multiple agencies, econsumer.gov, and organizations such as the Better Business Bureau and others. Currently, more than 2,800 law enforcement users have access to Sentinel, and access is completely free. To give you an idea of its size, since 1997, the FTC has collected tens of millions of complaints, with over 5.2 million collected in 2022 alone, 2.4 million of which were fraud reports. And with this data, the FTC identifies and reports back to the public on complaint trends. We do this, for example, through annual reports, or what we call data books, data spotlights, and interactive visualizations available through the FTC's Tableau data page. All of this information can be found from the FTC's website, ftc.gov, including at the link on the screen. But I'd like to show you a few examples of what Sentinel can do. So first, one of the things that we can see on Sentinel are trends over time. So for example, this chart here shows different types of complaints since 2018, such as fraud and identity theft complaints. And I'm sure you all have noticed that there is a bit of a spike around the time of the pandemic. Similarly, this chart shows complaint trends related to different types of imposter scams, such as government imposter scams, which are in orange, and business imposter scams, which are in blue. We can also look at international reports. This image shows all international reports, but we can also drill down into this data, including at the country level, to see the top reports, the number of consumers who are reporting financial losses, and more. And we can even drill down into reports by contact method to see how scammers are reaching out to consumers. So for example, here in 2022, 61% of consumers who filed a fraud report identified a contact method, with the most common being text messages, but with the most money lost overall to scams initiated through social media. And what I've just shown you, however, is only a small fraction of what is available to the public. And we want the public, ranging from our local law enforcement to our international partners, to use the visualizations and data that can be accessed and even downloaded. But that's just what the public sees. On the back end, behind the scenes, what I can't show you here, law enforcement, including the FTC investigators, attorneys, data analysts, and economists, can mine and analyze this data in a multitude of ways to inform our work. So for example, they can use Sentinel to identify law violations and targets, to identify potential witnesses, and of course, to see what consumers have said about businesses. In addition, we sometimes use the data itself as evidence in legal proceedings. Plus, law enforcement users can request and generate automatic reports and alerts, for example, to monitor trends or potential targets. And law enforcement users can also connect with other agencies that might be looking at the same issues or targets. And this ability to not just receive complaints, but to mine and sift through them is absolutely fundamental to what we do. Another important way that the FTC uses technology is through our tech lab. In our tech lab, FTC staff, primarily attorneys and investigators, have access to the lab, which provides them with anonymous internet access, various devices, software, and other technological tools to conduct investigations and research in support of the FTC's consumer protection mission. So we have numerous devices available to staff, including computers, mobile devices such as smartphones, tablets, and other Wi-Fi capable devices. We have wearables and other Internet of Things devices, peripherals such as monitors, cameras, recording equipment, and of course, various types of software and applications. And the tools available in the lab allow our users, our staff, to analyze and collect digital content, including images, recordings, and code, network traffic, data flows between devices, website information, including public social media information, usage data, viruses, spyware, and other threats. Our users can create email addresses, they can create mobile accounts to purchase apps, and more. Our lab is robust, but its origins were actually quite simple. It started many years ago as a computer that could access the internet. I'm pretty sure that this was dial-up. And since then, it has evolved to address mobile technology and eventually to Internet of Things and more. And the goal of our tech lab is to mimic and recreate the consumer experience. So in conducting investigations and research, lab users initiate the review and collection of information and access content that is already available to the public. So for example, if we want to see how an ad or a privacy notice is displayed on a website and a mobile device, we can do that and then capture that information as evidence. And if we want to know what consumer information is shared when a consumer interacts with a particular website or product, we can do that as well. And the lab is physically isolated from the FTC's production network, and staff can access the lab both from our headquarters in Washington, D.C., and all 8 of our regional offices. In addition, staff can also access certain tools remotely via VPN. And the technology that is available in the lab is vitally important because it allows us to independently monitor the market and collect evidence for our investigations and legal proceedings. And we can also conduct research into consumer protection issues associated with technology. And again, both of these are absolutely fundamental to what we do. Last, I want to mention our new Office of Technology. Our Office of Technology is a group of specialists, of technologists, who help the FTC understand the technology that we are interacting with. It's a team of a dozen people with various skills, including software engineers and AI specialists who work across agency matters, including by supporting our law enforcement investigations and actions. On our enforcement cases, the Office of Technology works directly with attorneys and staff to understand markets and business models, draft questions to obtain the information that we need, and to help us understand the information that we have collected and received. For example, they work with FTC staff to decipher the collection and sale of location data, to understand algorithms, and to track emerging technologies like augmented and virtual reality. And although this office is new, the FTC has used technologists for years. And this new office is a natural extension of the expertise that the FTC has relied on for well over a decade. By employing technologies within the agency, we can keep pace with technology. So looking back at these three things, the ability to mine consumer complaints helps us to identify problems in the market, including bad actors, locate potential evidence, and coordinate with other law enforcement. Our tech lab helps us to monitor the market and collect information, including about problems that we have identified through Sentinel. And then our technologists, including in our Office of Technology, help us to understand that information. So combined, these three things help the FTC to more effectively protect consumers and do a lot more than we could without technology. So thank you for your time. And if any law enforcement agencies would like to know more, my email is at the bottom of the screen. Thank you.
Thank you so much, Stacy, and thank you so much also to all the other panelists. I think it's very exciting to see and to learn how consumer organizations and consumer agencies now also use more and more tech tools in order to enforce consumer law. I think this is really something we urgently need, because what we observe is that companies are also getting more and more digitalized in the way they market their products, in the way they conclude contracts, in the way they enforce contracts. So therefore, it's actually logical that also consumer organizations and agencies react to this development by adopting a more technological approach. So therefore, also congratulations to the organizers of this conference and of the entire project. Without further ado, because of time constraints, I would like to hand over to Liz, who will now actually manage the Q&A session. Thank you.
Thank you so much, Martin. Martin's got to rush off because he's going to teach, hopefully, the next generation of technologists who are going to help with consumer protection enforcement, maybe that's what they'll end up doing. Can I ask everyone who spoke in the last panel just to turn their cameras back on, because that means we can put you back in the spotlight and bring you into the discussion. So we're going to have about 10 minutes for Q&A, and then we'll take a brief break. I'm just looking at the questions that have come in. There's probably relatively quickly to answer one for you, Louisa, which is about digitalizing redress. So does it reduce accountability on the part of authorities if the grievance redress mechanisms that operate at a national level don't actually respond to them? So in the absence of a physical authority, how can consumers know that and track the status of their complaints and ensure that they're actually resolved? So I think it's a question about, if we make this seamless and take away the physical authority, how can consumers actually see that justice is being done?
Well, we as consumer organization are in touch with consumers. So we need, if we do not solve the problem, the consumer come back to us and complain with the consumer organization itself. So we actually are there. Our mission is to solve the problem. A kind of side effect or parallel mission is also to serve the institution. So to try to, we need to, through the collective action, do something using the technology. This means that we can prepare the field. So we, for example, have, depending on the mechanism, we can enter in the collective redress mechanism, opt-in or opt-out, but let's say collect the class, identify kind of homogeneity of the damage. So we really can read how many differences there are between cases, how widespread it is. So we can for sure treat massive communication, also to keep the class informed during the time length of a class action. So that was a really burdensome issue without technology. So for sure, this could be a kind of new challenge for us, so to develop further what we have done for individual complaints to scale up to collective redress at the European level. But for the moment, we for sure, thanks to the technology, are able to read the cases, collect them, of course, also sue the company when is the case.
Yeah.
But yeah, the thank is not only technology.
Yeah,
it's,
so
of course.
yeah, and I think that's come through in lots of the presentations, that it's not that we're seeing to replace everything with digital, but it will be both working together. And a question's also come in for Ruth. What was the most challenging thing in setting up the systems that you talked about?
Yeah. The department does not have a lot of expertise in creating online or a technology that uses the internet. So that is one of the biggest challenges that we have. And of course, funding, because there are a lot of other priorities before we get to do any application using technology. So, well, these are the two basic challenges. And that's why, you know, the Philippine Online Dispute Resolution, I forgot to say, was a project provided to us by the USAID. So we thank the USAID, of course, for assisting us in creating the project with all their experts and their the funding assistance that we received from them. So that was a big help in completing the Philippine Online Dispute Resolution.
Okay, that's great. And I'm sure that issue of funding is something that will be picked up in the next panel. I also want to hear from EU Lab, the Netherlands and the FTC. Where do you think things are going? Where do you see this happening in the future? And Adam also says, is there a danger we'll always be outsmarted by business? So Stacey, what do you think of that first?
Well, I mean, it's always a little difficult to predict where we're going, but I don't think technology is going anywhere. And I think we're going to just have to keeping our eyes on the market and keep developing ways to monitor those markets and technology. And, you know, it will be a challenge. It's always a challenge to stay, you know, to meet the market and to stay up with what traders are doing. But I think that technology will hopefully really help us to do that. And also, you know, the focused application of technology as well.
Absolutely. Yeah. Laser-like focus. That's what we need. Dries, what do you think? Where can you see this going in the future?
Yeah, thank you, Liz. And I think I can only agree with Stacey that tech is only here to stay. I think just looking at trends, maybe also in digital marketing and where we apply those toolings, I think we're definitely going to need more tooling in terms of personalization. So I think fictitious consumer profiles to really see what consumers are being confronted with is something that we actually need and will be the next frontier. I think also we're going to see the increase, and I touched upon this briefly, in terms of AR and VR based consumer spaces. I think we definitely need to get ready to hold effective oversight in those, and I think that will definitely require more tech on our side as well. So, and in terms of being outsmarted, I think, yes, there is that risk always, and we're always going to lag a little bit behind. I think we're also really trying to, for example, build the scrapers that we use to use such patterns that they're not easily detectable by business as not being a consumer. So they actually imitate consumer behavior on a website. So I think that's something, for example, to think about. And the other problem that I see in terms of using tech is that, you know, the use of tech may also bias us. And that's something that we need to be very careful of. So, for example, we've built tools to find fairly simple violations, for example, the countdown timers. Now, the really sophisticated violations, so the code level or system level dark patterns, we will not find using those tools. So we need to advance the tooling to make sure that we also do not bias ourselves towards the easier violations. I think that's something also we have to keep an eye out for.
That's a really good point. Peter, I'm going to end with you and just ask, where do you think things will be going for your organization in particular now that you've started to try out with AI?
Actually, I think that the challenges are changing very fastly. So a few years ago, I thought that the challenge is to find the proper technology and to adjust it to our needs. But right now, as I am observing that the other agencies and also my own, that we have different types of tools. We can use them pretty nicely. And the challenge right now is to avoid this spaghetti system, to try to build that in a consistent way, to allow our workers to find out themselves in the system and use a proper tools for a proper violation. So that's definitely the challenge for us. And as I talked with Teresa a few days ago, we are the drivers of technological change. So having in mind this responsibility for us, it's very important to create the systems in our agencies very in a responsible way and with the appropriate set of tools for changing the violations.
Thank you. Okay, unfortunately, that's all we've got time for. We're going to take a 5-minute break. So grab drinks, food, take a break. And if you could all come back in 5 minutes, then we're actually proposing to finish at 15:10 so that we keep the final session also to an hour. So I do hope that everybody can bear with us for that final slight extension to the time. So thank you very much to all of our speakers on that panel. That was really fascinating and brilliant presentations and a great range. Lots of similar themes in terms of challenges, but also lots of very different approaches there too. So thank you, everybody. Enjoy your break and we'll see you back here in 5 minutes. Thank you.
So, dear participants, hello, and welcome to the last session of our event of introducing EnfTech. And in here, we will discuss EnfTech and international cooperation. I will ask my speakers to turn on your cameras, please, so we can all see you. I see Stephen, I see Sita, and I see Joanna. Welcome, all of you. Let me start with a brief introduction. We know that harnessing technology within and between enforcement agencies will be vital for protecting consumers active in today's global digitalized markets. Designing EnfTech in a way that works across borders will be vital and requires improved international cooperation. As Teresa mentioned in her introduction, 60% of countries responding to UNCTAD's World Consumer Protection Map report no experience in cross-border cooperation on consumer protection, and only 63% of cooperation agreements among consumer protection authorities include provisions on enforcement. To address this, and since 2017, UNCTAD's informal working group on consumer protection in electronic commerce exchanges information and shares experiences among its member states. Current work focuses on misleading and unfair practices, consumer education and business guidance, and cross-border enforcement cooperation. These are all areas where EnfTech is well placed to respond. We're honored to have with us Ms. Joana Calderon, Legal Director of ProConsumidor of the Dominican Republic, Mr. Stephen Kamukama, Manager of Consumer Welfare at the COMESA Competition Commission, and Sita Zimpel, Principal Advisor at GIZ Consumer Protection in ASEAN. We want to make this session as interactive as possible, so there will be opportunities for questions as well. Please put them in the chat box, and please be reminded that this event will be recorded. Well, now let's start right with our questions. First of all, Joanna, you are currently the president, and this is your consumer agency, ProConsumidor of the Dominican Republic. You're president of the Ibero-American Network of Consumer Protection Government Agencies, which gather practically all Latin American agencies, as well as Spain and Portugal. And this informal network has a dedicated working group on e-commerce and extensive experience in cross-border cooperation. So in your experience and your view, how can technology fuel cross-border and regional enforcement cooperation? What are the main areas of interest? Joanna, over to you.
Well, first of all, on behalf of our Executive Director, Dr. Eddie Alcantara, and on behalf of ProConsumidor and the Dominican Republic, we would like to thank you for kindly inviting us to such an important event. It is a great honor for us to be part on this stage. In answer to your question, Arnau, we understand that the only way that technology can collaborate is by promoting the guidance that are assumed after a collaboration agreement, which we are pleased to inform that it has already started regionally through the Central American Council of the Defense of Consumer Rights, CONCADECO. That is an agreement between the states that guarantees that the provider that is outside the territory of the consumer has the obligation to respond to the consumer when their rights are dishonored. In our opinion, there is no way that technology can force a country to apply a rule beyond its territorial limitation. We think it's not possible. Technology could contribute to the data and offer aspects, but there are no mechanisms available to enforce the existing law. We understand that as technology advances, cross-border trade advances in the same way, which is characterized by the fact that the supplier is in a different territory from the consumer, and in the same way, technological and cybercrime in transnational trade also continues to advance. That is how the regulations of each state are limited to preventive application at the territorial level. In the intentions of what are the guidance of the United Nations and other international organizations that are not adapted through the request of the mandate for the creation of norms for such purpose. With the purpose of promoting a future agreement on member state, there is no progress for us. If the United Nations doesn't understand through their own text sessions that a global collaboration agreement is imposed with all United Nations member countries, there is no way to protect consumer rights in cross-border trades. The Dominican Republic has carried out a fairly extensive study, which we wanted to present at the United States table in our participation in July, when we asked to schedule it. And we have raised in the members of countries of the Central American Council, CONCADECO, which we preside over pro tempore, and for which we have a collaboration agreement scheduled to sign on this month on the day 25. In the same way, we assume the presidency of the FIAC for the month of November. We will expand the spectrum of collaboration through a border agreement, and for the Dominican Republic, we will continue promoting this type of agreement in search of solutions, because there are none so far. The regulations of each country is what has to do with the protection of consumer rights are dormant. They are not updated as the growth of the electronic or cross-border commerce increases. This limits protection agency to consumers to guarantee the rights in this type of transaction. Though EnfTech and cross-border cooperation are essential components of consumer protection in today's globalized marketplace. So the use of digital tools, such as database to share information and detection systems for the prevention of violation of consumer rights, as well as joint cross-border work with a view to developing international standards, protection agencies to consumers can improve their response in terms of law enforcement and can better coordinate their efforts to more effective addresses cross-border violations of consumer protection laws to achieve more effective protection of consumer against commercial practices unfair or fraudulent.
Thank you so much, Joanna, for your answer. I'd now like to turn to Stephen, actually, and the COMESA Competition Commission is at the forefront of formal enforcement cooperation at regional level in consumer protection. How do you see technology supporting the work of the Commission and cooperation among your member states? Stephen, the floor is yours.
Thank you for having me. As the Commission, we are glad to be here because this is a very, very important topic, which as the Commission, we are very much interested. As you may be aware, the Commission, the COMESA Competition Commission, is a regional body, and we have jurisdiction over 21 member states. And because of this, it would be very, very difficult and for us to be able to be in each and every member state to monitor and survey the market to identify such misconducts in relation to consumer protection. So the use of technology is very, very important for us to be able to detect consumer infringements that happen online. It would be important for us for purposes of reporting, picking information from the various member states in the process of analysis, as has already been indicated by several presenters. Such technology helps so much in the analysis of the cases and improve in compliance, especially when the traders and the undertakings companies out there get to know that they are being monitored. So as technology will be very, very important because like we have mentioned, having 21 member countries where we enforce the law, enforcement becomes very difficult in terms of coordination, in terms of getting evidence, in terms of processing the cases. So with this information, with technology at hand, it would help much of our work. It would ease the coordination and collaboration with member states. And of course, we do know that when the technology is there, it also helps push the companies, because at the moment you'll find that we have countries that possibly don't have yet the laws in place. There are those that have laws in place, but in some cases they have implementation capacities, capacity challenges. And when we have an umbrella technology that monitors the market as one, such technology could help even in enforcing where there are weaker enforcement capacities in those countries. And at that time, it will also make the companies know that they are being monitored, and then on their own, they will regulate themselves, and that would be a plus on the part of this technology. And when the consumers get to know that there is such technology, then it helps so much in reporting, so that we are able to get reports from all the 21 countries directly from the consumers who will be using such technology. We are currently working on one which is going to be on product safety, specifically on tracking and reporting. And with the information we are learning even here, we'll be able even to extend it to even other forms of consumer protection. I thank you.
Thank you so much, Stephen. I see a trend already from your intervention and Joanna on the need for legal powers and a legal framework for cooperation to happen. I also like how you brought product safety, which is perhaps an area where enforcement technology has already been harnessed and the way that this can spill over. Let me now turn to Sita Zimpo. You have ample experience in supporting efforts to enhance regional cooperation in consumer protection. In your experience in Southeast Asia, what are the main aspects of enforcement that can benefit most from the application of technology? Sita, you have the floor.
Yes, thank you very much, Arnau. Let me just quickly check. Yes, thank you also to the organizers, Christine, Liz, UNCTAD, for having me, and also for showing some brief slides on the screen while I'm speaking, so you don't have to look at my face at all times. My brief intervention is from the perspective of the German Development Corporation, so I will not speak on or for consumer protection authorities in ASEAN, but hopefully also our observations can be enlightening in anchoring the discussion on EnfTech in the emerging consumer protection landscape we find in Southeast Asia. Next slide, please. Before starting to respond to your question, Arnau, let me quickly sketch the landscape of digital consumers that we find in particular in the ASEAN countries. Just to give you a little bit of background, this is a helicopter view, and you all are probably aware that when we talk about ASEAN, we're talking about a region that is characterized by a very high degree of heterogeneity and dynamism. There are currently a little more than 633 million inhabitants. They're spread across 10 different member states that are as diverse as Singapore, obviously a first world country and one of the freest economies in the world, versus Laos, PDR, quite similar in size, but also a landlocked and least developed country. And these contrasts also to some extent encapsulate the breadth of consumer protection systems and their maturity that we encounter in ASEAN as the region. These contrasts aside, however, there are a few trends that are important for our discussion on EnfTech as well. ASEAN leads in the adoption of new technologies and the growth of online platforms. We talk about GovTech, FinTech, HealthTech, EduTech, you name it, everything is there. Just today, I read about PropTech, about the property sector. So we have all of those platforms, and they're readily embraced by now an estimated 370 million digital consumers region-wide. And this includes, according to a report by Bain & Company last year, 14 million newcomers, new digital consumers in the past year in Indonesia alone. And these trends are actually driven and underpinned by increased internet penetration alongside a growing urban middle class, and of course also a growing working population over the age of 15. So seeing this, you would probably think, wow, that's fertile ground for EnfTech, doesn't it? Isn't it? Well, maybe yes, maybe also not yet. So that's the next slide, please. Where do we stand largely in ASEAN? We already heard a little bit earlier from the Philippines about various mobile and online apps that are also increasingly being employed by consumer protection authorities. And that aside, what we definitely observe is a focus on the digital delivery of justice in the wider sense and in very different forms, be it e-government initiatives, notably those that assist citizens in flagging grievances or issues related to public service delivery, be it legal tech, reg tech, what is mentioned from the private sector, and of course also the wider topic of e-courts, where we see also emerging initiatives across many countries in the region. Furthermore, particularly promising are grassroots projects, what has once been called by a legal tech association access to justice. So in particular, using new technologies, AI algorithms to source and simplify legal information, to automate e-filing, processing, referral of claims, to diagnose legal issues, and also to match legal needs with available legal assistance. Now, all of this is a little bit of a long-winded way of saying that these broader developments also stimulated the introduction of online complaints handling as a stepping stone for setting up national online dispute resolution systems specifically for consumers. So what I mentioned earlier was, of course, not specifically related to consumer protection, but the ODR topic, as also flagged earlier by Ms. Ruth, is aligned with an overarching commitment under the ASEAN Strategic Action Plan on Consumer Protection to put in place, at least on a pilot or on a first mover basis, the so-called ASEAN ODR network as a mechanism to enhance cross-border enforcement cooperation, particularly with respect to complaints handling. Now, I'm aware this is a little bit stretching the EnfTech definition. However, you ask about what are areas that are particularly if you will, attuned or suitable for the application of technologies. And the present focus on consumer access to redress, from my understanding, actually makes sense because it was found to be one of the most pressing issues undermining the effectiveness of consumer protection systems in ASEAN. In fact, the pilot implementation of the ASEAN Consumer Empowerment Index in 2020 and 2021 attested only a moderate degree of consumer empowerment to the more than 7,000 consumers surveyed for this pilot index. And one of the main reasons was actually for this lack of empowerment, the lack of awareness also about the availability and the accessibility of redress options and mechanisms. So summing up my response, applying technology at the stage of dispute resolution is undoubtedly a priority, both domestically and prospectively also across borders. And it's a good start to also look into EnfTech opportunities or good practices. Efforts should not be confined to a stage where essentially the harm has already been done. So the preemptive ex-ante tech solutions are worthwhile looking into also for ASEAN. For example, how to tap tech tools for tackling certain unfair business practices on online platforms. However, this is where we see very little to build on still and a lot to build up still in ASEAN for the time being.
Thank you so
much.
Thank you so much, Sita, for this very comprehensive participation already, and I like how you make us stretch our definition. It's very refreshing too. Let me ask one question to all our speakers. So we've heard what are the potential benefits of applying emerging technologies to enforcement cooperation in consumer protection. Now let me ask all of you, in your view, what are the challenges or skills and capacities within authorities that you work with or within to both develop or to procure tech tools? What are you still lacking in your human resources? How about we start with Sita this time, and you only have 3 minutes.
I try my best. There's one last slide actually that I wanted to show very quickly here for responding to your question, and maybe the organizers can put that on the screen while I start. So for sure, there's a lot to be inspired by and to aspire to when it comes to EnfTech also in ASEAN. However, as was mentioned earlier, exploring emerging technologies for enforcement and an extension enforcement cooperation on consumer protection would also need to be matched with the situation on the ground. In ASEAN, we have countries like Cambodia that are on the verge of graduating from a least developed country, and they are the youngest consumer protection regime that has a law only dating from 2019, and they basically need to learn to run while they are still learning to crawl. So they need to put in place and work on the basics while already addressing a need and ambition for more advanced solutions that also address digital and cross-border trade, for example, irresponsible sellers on online platforms. Now, for this quick reality check to uncover additional issues in ASEAN, you can see on the screen, I would not want to shame or blame individual countries, but to sensitize and caution about prevalent limitations that could run counter to the otherwise innovative potential we already see, in particular outside of governments in ASEAN. So one of the first challenges we observe in authorities is, as was mentioned as well, limited technical or specialized capabilities to develop or procure tech tools. I have to mention that many of the consumer protection authorities in ASEAN are part of trade ministries where they need to compete with other economic priorities. And that, of course, inevitably translates into scarce human resources and financial resources in many countries to effectively implement or even expand their mandates. And of course, we can always say, no, some are more equals than others. In some countries, consumer protection ranks comparatively lowly, and the introduction of new departments on e-commerce actually intensifies this internal competition for resources. Second point that we see as a challenge or constraint is limited political will to introduce or test innovative approaches like EnfTech. Very often we encounter more conservative or cautious stances among government officials. Then we have also sectoral egos working in silos. So being progressive or visionary is not always enough, and it's not always easy. Technological change is one thing, institutional change is another. What we have learned, for example, in our work in the ODR context is that it's often overlooked or underestimated what it takes to promote not only a common understanding across government agencies, but also within. And in many countries, authorities will be hesitant unless there is a legal obligation from the top. And decision makers may be very difficult to convince about even simple approaches. For example, in Vietnam, we applied a user-centric design and a Facebook-like interface for complaints filing online, but it took essentially, I don't know, 2 days to program. I'm exaggerating a little bit there, but 2 years or a little bit more than 2 years actually to persuade internally decision makers within the authority. And last but not least, I will echo what also was said in the beginning by Christine in her introduction. The third challenge is limited cooperation experience to learn from and to link up with regional and international partners or peers. Consumer protection, particularly in ASEAN, continues to be primarily inward-looking and comparatively context-specific, and this is compounded by regulatory frameworks that are at varying stages of maturity. With this setting, it's also hard to program new technologies like AI, and the absence of binding supranational rules is also difficult because that would not facilitate, there's nothing that facilitates or little that facilitates or incentivizes cooperation. And even though we have, as was mentioned also, the ASEAN Committee on Consumer Protection, where all 10 member states have the consumer protection authorities participate, actual enforcement cooperation is still difficult to come by. For example, also because of practical issues such as connectivity, language barrier, inconsistency of legal provisions, not enough data to work with, etc. And so this adds to the fundamental questions on the applicable law and the legal obligations. And behind that may also be fears over the inadequacy of tech, potential failures, or even misuse. To end, however, I would like to be a bit more positive and mention that despite the challenges I just sketched, there is also a lot to hope for. I'm using the illustration that you see on the screen right now. It's a Malay idiom about the frog under the coconut shell. So the frog is under the coconut shell, and that's his whole world. It's everything that it knows. But once it gets out, new views and new opportunities open up. Similarly, we can expect considerable benefits from regional and international exchanges and cooperation. There is pronounced potential in ASEAN for EnfTech due to high tech affinity, potential tech talent, and advances in digital connectivity. But we also need incremental small steps and patience to change mindsets and rather rigid government structures in some of the countries. And to overcome that, fostering mutual learning is an important step. And also there are a lot of merits that we see in participating not only in regional fora with your peers, but also in international discussions like today outside of one's respective coconut shell. That's it from my side, Arnaud. Thank you.
Thank you so much, Sita, for this comprehensive yet very precise and hands-on answer. Let me turn to Stephen with the same question. In your view, Stephen, what are the challenges of skill and capacities of authorities, both in developing or procuring tech tools?
Thanks. Thank you so much. Majority of our, if not all, actually all our member states are developing countries. And the immediate issue now that comes in is resources in terms of funds to be able to procure or even design these technologies. The infrastructure that is involved, the equipments that are required, the internet, to be able to have reliable internet to run these systems is a challenge. When it comes to the institutional level, you'll find that at the moment, majority of the staff that we'll be having across the region, even at the Commercial Competition Commission itself, would require reorientation in terms of how we'll be able to now generate data, because from what I have heard, what has been presented, such softwares, they would require data sets or definition of concepts to be able to feed the systems to generate the results expected. And that may not be the way we've been doing things. That requires reorienting and training the existing staff. But even then, that we talk about technology, we just also need more staff, the ones who are trained in IT, who would then be able to run the systems. So the resources required for all these to establish even units, because the way we are structured, for example, now we may require a technology department, an IT department, to be able to run these systems. All those are resources and gaps that we do have. The language barrier, which has already been mentioned, is an issue because when we apply the technology, it has to apply across all the 21 member states, and that, of course, would present a challenge of language, given that there are various languages in those member states. That is at the institutional level, but overall there are other challenges that would affect the implementation. One of them is the standard. You find that in different countries, they have different definitions in their legal documents. They define concepts differently. They have different scopes. So the scope of application is also different. And as we now design and try to come up with a standard system to apply to all countries, that then becomes a bit of a challenge. Now, one other thing that we still have to note is that technology is not going to remove the jurisdictional limitations. So even if we assess, just for the sake of this discussion, we assess Alibaba and see limitations, sometimes at a country level, it may be difficult to make some interventions. So that also will remain a challenge. And the other challenge that we still see, which needs to be handled, is that the technology is moving into area where we are using artificial intelligence, and therefore, as we develop our own artificial intelligence at the authority level, the companies themselves will also now apply their own artificial intelligence to be able to monitor and understand another technology which is coming in to monitor them, and they may invade that. Now, to be able to track that, to keep up with that at the authority level is also a challenge that we are foreseeing. One other issue is that there are technologically based practices, but they themselves are not technological. They may not be detected by the technology itself. And maybe later on it could happen, but for now there's a bit of a challenge. For example, a label fixed on a product which is being advertised, and a safe product which is being sold, at that point, it is being marketed on the digital platform. It's an unsafe product, but the technology may not be able to detect it as an unsafe product. So there are those that would now remain, and which we also have to make sure that we don't sway away, and we still have to focus on them, because they are also very important areas of consumer protection. The last one, which I may need to talk about, is that unless we have a way of putting the technology at the regional level or country level, not necessarily at the institutional level, to be able to guard against such practices, we may still remain with ex-ante problems, whereby we will still get reports from the consumers, from the market, that the harms are still going on, and we'll have to continue now relying on using technology after, as not necessarily to prevent practices from happening. So those are the ones that we are foreseeing, but of course we have also picked a number of others as presented here by the other presenters. Thank you.
Thank you so much, Stephen, for giving us this bird's view on especially on the strategic orientations that agencies need to appropriate before EnfTech can be fully deployed. Last but not least, Joanna, the same question goes to you. What are the challenges of skills and capacities in your authority, or the authorities that you work in your regional cooperation, to both develop and to procure tech tools? Thank you.
I had my phone off. Thank you, Arnau, for the question. In our opinion, according to the possibilities that the countries have and provide to the consumer protection agencies, we don't have any challenge when challenged in applying the law in electronic commerce when the provider is in the same territory as the consumer. But when it is outside the territory of the consumer, the barrier will always be extraterritorial limitation. Technology has to be enforced in order to help and avoid consumer rights fraud when the provider is outside the territory. If the technology doesn't improve, there is not possibility, because all preventive, sanctionatory, or precautory actions must be through international agreement. Otherwise, technology cannot force a country to apply the laws in another state when the provider is located outside the territory of the consumer. Technology could contribute to ensure that consumers are oriented, that the data is preserved with a certain degree of rigor, and the guarantees in the end cannot be executed in case of breach. Could have been better type of clarity when there are none, any circumstances. In the words of our executive director, Dr. Alcantara, what we are discussing and proposing today does not solve at all the problems in the challenges to protect the cross-border consumer. To give an example, if the provider is in the Dominican Republic and the consumer is in the United States, for example, or vice versa, how can we act to protect the consumer? This does not help at all. Because we have carried out studies that have shown that by the year 2040, 90% of the transactions will be electronic, and the 65% of these providers will be outside the territory, and that no regulation has been enforced to protect or claim to recovery of the consumer's rights.
Thank you so much, Joanna. I understand this was the end of your intervention. Thank you for this call for an international legal framework to vehicle international cooperation. We're coming to a close to our panel. I'd like to take this opportunity to thank colleagues who have written questions, and also those who have answered questions. I'm particularly fond of Liz's call for technological literacy of consumer protection agencies, and this is also what we try to contribute from EnfTech in disseminating good practices and exchanging experiences. Perhaps we can go to a last question before we close the panel, and this will be rather a closing remark or a wish list, if you wish, on, and I'm going to ask the same question to all of you. If we look at the future, what would you identify as the one single improvement which could be most impactful in improving cross-border and international cooperation in consumer protection, including through your use of emerging technologies? I'll start with Joanna. What is your view on this? What could you take as a takeaway?
Thank you, Arnaud. For the Dominican Republic, the only improvement would be the creation of a cross-border agreement between consumer protection agencies promoted by the United Nations for a faster and more efficient exchange of information through a database that could be regional or global for monitoring various types of incidents in consumer affairs, both with suppliers of local goods and services, as well as those that operate at multinational level. The Dominican Republic made it itself available to present the studies that we have on the subject and try to clarify the real situation regarding real cross-border consumer protection.
Thank you so much, Joanna, for that call. I'll turn to Stephen. Stephen, if you look at the future, what could you identify as the one single improvement that can be most impactful in improving cross-border and international cooperation in consumer protection, including through the use of enforcement and emerging technologies?
Thank you so much. Well, the presentation has been made by various presenters shows that some of them have already reached there, but some of us who have not reached there, one thing that I think we as COMESA would wish to have is a regional platform that is able to query and detect from other platforms, detect the harm, receive complaints and analyze them based on the information picked from other platforms, from the retail and other trading platforms. Be able to provide alerts to the authorities, and even to the culprits themselves, to the traders themselves, and profile and publish the harms, especially the trending harms, and validate and show us which platforms are compliant and which ones are not compliant. Which, if we can have that at the regional or even international level, that's such a platform will be very, very good for the consumer protection agenda. But that's to happen. Also, we, as we have alluded to our previous intervention, would developing countries in particular would require interventions relating to training and capacity building of the staff, and also in acquiring the relevant technologies, because it may not be that straightforward and easy for authorities in developing countries to acquire such technologies. In addition to being able to facilitate the analysis and detecting the harm, such software or technology should also help in information sharing and collaboration among authorities, including between developed and developing countries, to be able to easily enforce, since we now know that the people who are involved in such practices are all over the world. They are not necessarily within one jurisdiction. So we really need cooperation, and such software should be able to facilitate cooperation. Thank you.
Thank you, Stephen. Now, finally, over to you, Sita. What is your single improvement that you think would be most impactful?
That's very hard to answer. A single improvement. I mean, I would not be able to drill it down to one topic or one tool. I can, of course, echo what was said earlier, that in the long term, it would be good to have an overarching international kind of cooperation arrangement, maybe starting regionally first and then going there, but that takes time. That's something that's not easy to come by. And so in the meantime, I think what would be a very good improvement and a very good impactful improvement as well is to really have government authorities, consumer protection authorities listen or look into what is also happening outside of the government. So what do we see? What is done with legal tech companies? What's done with grassroots initiatives in communities where we are trying to match needy people with pro bono services? Are there certain ways on how we can transfer experiences from that part of what is done in, for example, facilitating consumer or citizen access to justice? How can this be perhaps also taken up by consumer protection authorities and advocated for internally in governments in ASEAN and elsewhere? So it would be more really moving or converging with experiences in the private sector and in civil society, rather than just standing in the ivory tower of the government and thinking, okay, this is very difficult for us to do, because there's a lot of inspiration out there. And as mentioned also in the Philippines, by the Philippine colleague earlier, we can find the resources to move forward with these kinds of initiatives, but we need to have a case for it. We need to have the inspiration. We need to tap in on innovative potential and talent that we also sometimes find outside of government agencies. So that's perhaps the improvement or the openness that I would call for here. Thank you, Arnau.
Thank you so much, Sita, for your inspiring wish. So I take it that we are going to need international or at least regional legal frameworks for cooperation that are binding among countries. We need to pool resources at regional level to enhance capacities and to multiply the effect of EnfTech. And finally, we need to get out of our coconut shell and look outside to improve our capacities as agencies. Thank you very much to all my speakers. I would like to thank Joanna, Stephen, and Sita for sharing your experience and vision, and our participants for questions and comments. I would like to share my conclusions of today's session on international cooperation. So international cooperation in consumer protection is increasingly regarded as an effective way to improve the welfare of citizens across the world. It allows for the exchange of experiences and peer learning, the building of consensus and agreements, the improvement of cross-border enforcement, and for the technical capacities of government officials, as well as awareness raising and engagement of relevant stakeholders. Cross-border cooperation, especially in enforcement, is still relatively uncommon. And with the exception of the European Union, it is currently based on interagency informal cooperation, which may be insufficient to adequately address the growing number of cross-border unfair commercial practices. Neither does it allow for satisfactory dispute resolution and redress for consumers, especially for those who shop online, ultimately hindering consumer trust in digital markets. International cooperation at regional and multilateral levels could benefit from more regular exchanges of information between international institutions and networks on work programs and topics for consultations, which should lead to identifying common projects and avenues for cooperation while avoiding duplication. We may need to rekindle traditional approaches to cooperation and harness technology harness technology to overcome existing barriers, such as the applicable law and jurisdiction, the lack of legal powers to address cross-border unfair commercial practices and to engage in cross-border cooperation, handling information confidentiality, and language barriers. Artificial intelligence, machine learning, chatbots, and blockchain can be used to address these issues. From previous panels, we have heard some valuable insights and challenges that also apply to international cooperation, namely the advantages of using tech to speed up routine tasks, the need to choose the right technology for the task, the need to join up across authorities to share best practice and learning, the challenges of skills and capacities within authority to both develop and procure tech tools, which has also been discussed in this panel in detail, and the challenges of bringing the organization on board with changes to a tech approach, as all departments should be engaged, and as Sita said, as all departments in government should be engaged. A good starting point is to build cross-border cooperation at regional level while benefiting from international networks, namely the International Consumer Protection and Enforcement Network, the OECD, and UNCTAD. It is commendable that regional economic organizations and networks in consumer protection are present today in all continents. Policy coordination and exchange of experiences are the basis of all regional initiatives. Policymaking on consumer protection mainly happens within the framework of formal institutions, such as regional economic organizations, on the basis of provisions directly or indirectly related to consumer protection. And this is the case of ASEAN, CEMAC, COMESA, the ECC, the European Union, and Mercosur. The European Union has the only fully functional mechanism for formal cross-border enforcement cooperation in consumer protection at regional level. And the European Union and the Organization of American States both have operational regional cooperation networks in the field of consumer product safety. Regional organizations are thus called to play a leading role in disseminating the application of EnfTech and raising the capacities of its members. Two substantive issues stand out, and I'm coming to a close: e-commerce and product safety in international cooperation and in the work that UNCTAD has been conducting on this issue. Finally, and perhaps most importantly, international cooperation in consumer protection is only feasible when effective national laws and policies and institutions are in place. And although most developing and least developed countries participating in UNCTAD's World Consumer Protection Map reported having enacted consumer protection laws, the majority still need support in reviewing them to keep up with recent developments or developing secondary legislation, as Teresa had mentioned in the opening remarks. They also need to build capacities of institutions to effectively fulfill policymaking and enforcement roles of consumer protection, especially in improving technological capacities of case handlers. For this purpose, technological cooperation at bilateral level and through international development organizations must remain a priority for all actors with stakes in consumer protection. Thank you, and over to Christine and Teresa for the final segment of our event on next steps.
Oh, thank you so much, Anna. And what a great panel that was. It was fascinating. And so I think we've had a very busy 3 hours. We were a bit worried 3 hours would be very long, and I haven't seen the 3 hours. I've got a few thoughts before I hand over to Teresa, but first I'd like to give a big shout out to my team, Laura Ad and Constanta Rosca, without whom the technology would not have worked. So they deserve a big round of applause. They have worked tirelessly to make this happen. And also to Liz, who have really spearheaded a lot of this event. And of course, to all of our speakers and chairs of panels. It's been really fascinating. I think for me, my takeaway is, it was reassuring to see that much is already going on. When we were scouting the internet for information, officially there is not that much that shows, but clearly when we started to unpack, we saw that there was activity. And I hope that after today, we can see EnfTech snowball and its use be refined. We've heard how useful it can be and how beneficial it could be for consumers around the world. And there seems to be a consensus that we can move to an EnfTech phase in consumer protection. I think it'd be greatly beneficial to make sure we stop talking just about regulating tech, which is what we've done a lot, but harnessing tech in order to create better markets for consumers. The project will continue. We've got quite a lot on our plates. Clearly, for me, it's not only to try and now develop a framework on how and we can use technology, we can use it safely, we can use it effectively, but also looking at how the legal infrastructure as well as the technical infrastructure that is needed in agencies can also be developed alongside it. Without the background, there will be no EnfTech in the future, and consumers I think, will be less protected. So on that thought, I would like to thank you very much. And I also would like to thank Teresa and her team for this great collaboration. And now over to you, Teresa, to close the conference.
Thank you very much, Christine. And well, let me just join Christine saying that I thought it was a really exciting and very interesting set of presentations and sharing of experiences. Frankly, I'm also very encouraged because I think, as Christine was saying, that we realize that so much is already happening, and that consumer protection agencies of different parts of the world are developing their own tools, and they are engaging either with neighbors or close partners in order to be able to do a more effective enforcement, which ultimately is what this is all about. I also wanted to join Christine's remark in what concerns the, between brackets, regulating tech. I think you are quite right. I think it is about time, let's put it like this, that enforcers, that government agencies also make the best possible use of the opportunities provided by digitalization, also to improve their organization, of course, to identify in a clearer, quicker manner consumer complaints and claims, and of course to scan markets looking for signs of unfair commercial practices that require enforcement action. I think what was also particularly encouraging was that also some developing countries, but of course countries that have very vibrant consumer protection communities, let's put it like this, either because they have very active consumer protection agencies, or if this is combined with very vibrant consumer organizations, which of course are extremely important. So developing countries are not necessarily so much lagging behind. But I think, of course, there is quite a lot to do, and we are extremely happy to have been able to co-organize and join Christine Riffa's and her team in this project. Let me say that we were all very inspired by the great benefits that emergent technologies can definitely bring to enforcement of consumer protection laws. And that I also wanted to share some takeaways, just 3, not to take much longer. So, of course, and from the point of view of UNCTAD, as you can imagine, we do think that this, in a way, our first point is always that the governments need to work towards ensuring that consumer protection enforcement agencies have the necessary human and financial resources to promote effective enforcement, to encourage effective compliance, and to obtain or facilitate redress for consumers in all appropriate cases. And of course, it is true that EnfTech and any development of digital nature requires funding, and it is extremely important that all member states, in our case, are fully aware of this. The second point is that consumer protection enforcement agencies need to improve their capacities in EnfTech, that is to say, to really invest in training, specific training, in skills, in hiring data analysts and other experts that can assist them in gathering information, in putting in place, in testing tools, etc. This, of course, will imply recruiting experts and training the existing staff. I think the point on EnfTech literacy was very, very appropriate, I think. I mean, we are still struggling, I mean, from the point of view of UNCTAD, considering the diversity and the number of our member states with digital literacy, just as users, so to speak, or navigating the net, let alone on something so complex as EnfTech. And the final point is really, as other speakers have mentioned, that exchange of experience need to intensify between a larger number of countries, and allowing for less experience and less resourced countries also to benefit from the advances, from the achievements of the most advanced consumer protection jurisdictions. And here I join also CETA, including also reaching out, of course, to all relevant stakeholders. You know that in any case, when we advocate more effective consumer protection around the world, we always follow a multi-stakeholder approach, because despite, of course, some or many rogue traders, you cannot really enhance consumer protection without the engagement of businesses. And in this case, they are the ones that often have developed these new business models and new tools. So of course, we can always learn from them. Also, we believe that a very lively and active civil society, so consumer organizations, grassroots organizations, are extremely important. And several of them are also doing their own path with the resources that they have available, but they should also be brought to this issue, so to speak. And as far as international organizations are concerned, of course, ISPAN by definition is a very interesting platform. UNCTAD is privileged also to do so, as I said, because it is the largest platform, because we have work on e-commerce, as you will know, of course, more from the point of view of international trade and development, which is our broad mandate. But this has allowed us also to benefit and to identify best practices that we can build upon. And we think that the beauty of international cooperation is that it allows for many sort of arrangements, understandings, formal agreements, regional economic organizations frameworks, memoranda of understanding, and just cooperation between agencies. And all of this can actually provide very interesting inputs to improve overall international cooperation, which I think is more than needed in this area. So we think that here we have an even better case to stand for increased international cooperation, because it can really play a major role in all sorts of technology transfer. So really, to end, I would like to close this event by inviting all of you also to join us in our upcoming annual Intergovernmental Group of Experts meeting on consumer protection law and policy, which will take place in Geneva on 3 and 4 July this year. And on the morning of 5 July, we will have the 14th meeting of the UNCTAD's Research Partnership Platform on Competition and Consumer Policies. And we hope that we will be able to address and also to hear about these developments and hear from other member states and other partners in these two meetings, which are really gathering all of us for these purposes. As you know, these meetings, of course, gather member states representatives, but quite a lot of other stakeholders, starting with academia, with consumer organizations, business organizations, and of course, other international and regional organizations or networks. So we hope to welcome you in Geneva in early July to continue this discussion and even to see how we can also support the project a little bit further. Thank you again to Christine Rifa, to Liz Cole and that team for their excellent co-organization of this event. And allow me to thank my colleague Arnau Izaguirre also for his important role. Stay well and until very soon. Thank you.